Ms. Knipfer.
May it please the court, counsel. Children are different. They're a work in progress. And because of this constitutional recognition that children are different from adults, the defendant comes here today to request that the court find that the Iowa Constitution categorically bars sentencing juveniles to life without parole. For the last 10 years, we've seen substantial changes in the Supreme Court's holdings on regarding juveniles.
Can I interrupt you for a second? I'm sorry, but do we really have to go categorical if we're going to reverse this conviction? I mean, this district court didn't have the benefit of our decision in seats. Do you think that the sentencing hearing that was provided by the district court even complied with seats?
I don't, Your Honor, but I submit that the court did have those 5 principles or factors set in Raglan, taken from Miller. I mean, it didn't have the seats opinion, but even considering those 5 factors in Miller, it still didn't comply with Miller. But we would submit here today that the court should go on, even if it finds that it didn't meet the proper standards of seats, the court should still go on and find that there's a categorical ban.
It seems to me we have 4 options here. Number 1, to affirm the district court. Number 2, to say that the district court didn't follow seats and return it down to the district court to do a sentencing in accordance with seats. Because in seats, one of the requirements is that they have to find that he is there's a presumption against life in prison, number 1, and they have to make the specific finding he is irreparable, corrupt beyond rehabilitation, and thus unfit ever to re-enter society. So you got that wasn't found. The other thing we can do is, based on this record, just sentence him to life in prison with parole and do it ourselves. And then categorical. Why do we have to jump to the categorical one, which is the most strongest one, when there's at least 2 in between that may or may not get us, without extending the law as a categorical at this point?
You're going to see this issue come up again and again and again. And I think the court should now just address it. And
I'm sorry to interrupt,
why send it back when he's going to be,
But if we're finding out that judges are applying seats in a principled manner, and maybe some get life in prison without parole and some get life in prison with parole, but until we're assured that the people who get life in prison without parole are the people under Miller who should get life in prison without parole, then and only then should we reach the categorical, because I'm not so sure that Mr. Sweet should get life in prison with parole or life in prison without parole because of the way the hearing was conducted. And that's my problem of just jumping over 2 steps.
right, and I mean, your opinion in seats, indicates that, but defendant submits that here, in his case, he had those 5 principles of Miller, and the court still got it wrong. And the court out and out rejected his age.
Is it your position that if we don't address the categorical challenge, we're just going to have kind of cases going back and forth, and we need to address the categorical challenge?
That too, because just look as Mr. Buller asked the court. We have another case coming up that he asked the court to also consider. This, what's going to happen is this is going to. So say that you send it back to the district court. If you get the same judge, based on the language that he said in his sentence, in his ruling, he's going to find that life without parole because based on the wording that he sent there. So we're going to appeal again, and it's going to be right back before you.
Well,
What's the authority?
do we adopt rules just because it may be more burdensome and difficult for us to try to achieve a sense of justice in a case? I mean, should we shy away from an individual assessment just because it might be hard to do?
Well, in Graham and Roper, I mean, they said the difficulty was just, and I think it applies in this case. In Graham and Roper, they said, given the brutality of what took place, and this particularly applies when you're talking about a murder, that it's just too, the risk is just too much that the judge is going to be overpowered by the brutality of what took place. And that is so obvious in this case when you look at the judge's sentencing and his reasons for sentence. He is so, and understandably so, disgusted by what Isaiah has done in this case, that he talks about how he cold-bloodedly murdered his grandparents, how he went out and sold their belongings. I mean, this judge is just repulsed at the conduct of the defendant here.
Is it, if truly Mr. Sweet is entitled to life with parole under the Iowa Constitution, is it doing a proper service to him to send the case back for another hearing? If
No,
categorically he's entitled to life with parole?
No, I think if we believe that that we should have a categorical bar, it's not doing anybody any good to send it back and then come right back before the court again.
What's your best argument that, assuming we don't apply a categorical ban, that this case is not one of the rare ones that justify life without parole?
It's supposed to be a rare one to justify life with parole. Or excuse me, I'm getting it backwards. I'm sorry. What's the best reason that this would be life without parole?
He murdered his grandparents who had raised him since age 4. He planned it. He stood behind his grandfather with a baseball bat, changed his mind, went and got a rifle, shot him dead. His grandmother woke up. He loved her. He shoots her dead. I mean, if this isn't the rare case that would justify life without parole, what is?
What is? Well, first of all, you need to consider that we're looking at a juvenile who already, by nature of the fact that he's a juvenile, has less culpability. But we're sentencing him to the most harsh penalty that is allowed in Iowa, which I think makes this case more analogous to Roper, because the harshest penalty was death, but in Iowa, it's life without parole. So he's already got one notch of the lessened culpability. But unfortunately, there are worse cases such as Mr. Bentley, who took a little girl who was going to testify against his brother and raped her and murdered her and stuffed her in a cupboard. That's worse. Or, a case where someone nabs a little girl, takes her out, and with his own son sitting in the front seat of a truck, goes into rural areas, takes her into the cornfield, rapes her, murders her, then goes back to the truck where his son is sitting and goes on about his business. Those are worse cases than this one. This is bad.
But under a categorical ban, if a 17-year-old did those crimes just shy of his 18th birthday, they could not be sentenced to life without parole?
That's true. But in those cases, the first thing that we're looking at, and this is, again, going back to Roper, you're looking at the worst offense allowable. And already you start off with I guess I call it, one notch down. He is a juvenile, therefore he's less culpable. And so he is not deserving of the same level of punishment as an adult.
If it's a good idea to adopt a categorical ban on life without parole sentences for juveniles, why is only Massachusetts done so and not any of the other 48 states?
Well, somebody's got to be the first. And, this is still...
We'd be the second.
We would be the second. We've been the second and third in other cases, or even the first. It just, somebody's got to be at the beginning. And I'm sorry, can you repeat your question?
Well, let me ask you a different one. Your brief relies heavily on international law and what other countries are doing. Shouldn't the Iowa Supreme Court give greater weight to what our elected legislature has done in Iowa on sentencing policy?
Well, I think the court always gives weight to what the legislature has done, but at the same time, this court has a duty to exercise its own judgment and reflect upon what their history and the text, and to look outside its jurisdiction, and that includes even looking to what other countries have done. Roper and Graham definitely looked and said, more towards the end of its analysis, but said, look, we're the only country, or we're one of two countries that impose the punishment that's in question. And we are part of the, of this world, and I think what other countries do is, and should be, influential. I guess at this point, I want to talk about the principles for justifying life without parole, or the penological principles. When you look at first retribution, the courts have rejected that because when analyzing in terms of whatever punishment was in question, because juveniles are less culpable, that retribution doesn't come into play. Nor does deterrence, because juveniles don't think through what they're doing. And in Isaiah's case, yes, he planned to get rid of his grandfather because his grandfather was, in Isaiah's mind, was abusive, and he wanted to go out that night, and he was grounded. So, but he didn't think through, well, what happens next, And you see Isaiah's immaturity even in the fact that after he kills them, he goes and tells his friends. It's almost like he's going and bragging and trying to gain further acceptance from his friends. See what I've done? Do you want the truck? Do you want the TV? I mean, just clearly irrational. And the third factor of the courts consider in looking at punishment is confinement. And when you talk about confining a juvenile who's still a work in progress, you've basically sentenced them to death, because life imprisonment the court has equated with death, and you've judged this person as absolutely not able to come back into society. And the fourth factor is rehabilitation. And when you sentence a juvenile to life without parole, you're saying they're not rehabilitatable. And not only that, but the prison system reinforces that by virtue of the fact that they're sent to prison. the system knows that they're never going to be released, so they never get the training, they never get the counseling, and it just spirals down from there. I see my time is up. Thank you.
Thank you as well. Mr. Bowler.
May it please the court. Isaiah Sweet is the uncommon juvenile offender who deserves a sentence of life without parole. He is highly culpable and he cannot be rehabilitated. And where I want to start is by putting this case in context among the rest of our juvenile sentencing cases. Because,
Mr. Buller, tell me why this one is worse than Seats, because this fellow strikes me as some distance from Seats, who is really, that was an execution, a very venal crime. This seems to be an individual who had significant substance abuse and mental illness issues.
I think this case is worse than Seats, rather, both quantitatively and qualitatively. In terms of quantity, a double homicide is necessarily much more severe than the single victim killings that we've seen. 2 people's lives were taken here. There is a problem in trying to quantify what is the worst crime. That's very hard to do. We have gradations of crimes in Iowa, and of course, murder in the first degree is the most severe penalty we recognize. It's a Class A felony. Qualitatively, this case is different too. This was planned, this was premeditated, it was cold-blooded, and it was calculated. Isaiah Sweet told Agent Rieger that he'd thought about ways to kill his grandpa millions of times. He'd even researched it on the internet. He thought about using a bat. He decided he didn't want to go that way. He picked an assault rifle because it would be effective. He picked hollow point rounds.
First-degree murder is always premeditated, so anytime somebody thinks about it and plans it, because that's the definition of first-degree murder, they should get life in prison without parole under your argument.
Not all premeditation is created equal, Your Honor. Our case law recognizes premeditation can be as brief as a moment. Here we're talking about a long-term planning, millions of times.
So if it's a minute, we don't give them life without parole, but if it's 10 minutes, we do. If it's 15 minutes, I mean, where do you draw the line?
Well, of course, the problem is this is a line created by the court. The legislature had clear boundaries set up before.
So maybe the line ought to be taken away and drawn in a different place. I mean, the dispute of which of these constellation of facts is more heinous or not more heinous argues for a categorical rule. What kind of clear rule can you give us to distinguish between those rare cases, at least under the United States Supreme Court has reserved the issue on rare cases? I mean, if we were to adopt a case-by-case approach and not have categorical, we're looking for some kind of rule to segregate those rare cases, and I'm curious to hear what your rule would be.
Well, the problem with that, Your Honor, is that a bright line rule is the exact opposite of what this court keeps saying in juvenile sentencing cases. This court wants an individualized sentence. So consistent with our case law, unless we're going to overturn Knoll, Ragland, Pearson, Lyle, Lewis, L, and Seats, I can't give you a bright line rule because this court wants individualized sentencing.
But we're exactly where the U.S. Supreme Court is. I mean, they've reserved categorical. They haven't ruled it out, and we haven't ruled it out because we want to see, I think it's fair to say we want to see how this plays out and how our judges apply these factors. The problem I have on this record is that we said in Seats the law, I think you agree with that there's a presumption against this.
Yes, Your Honor. And
the state's asking for it, so they're going to have to rebut that presumption somehow. And the testimony at trial was, and the court even put it in his ruling, that 75% of these juveniles deceased this activity after 25. But the state has no evidence in this record telling me that this guy is in the 25 that aren't rehabilitatable. And one of the things you have to show in order to get life in prison without parole, I think we made it pretty clear in Seats, is that he is irreparably corrupt beyond rehabilitation and thus unfit ever to reach society. And I don't know how you get there under this record. And maybe you could explain how this record and the state has presented that to get him life in prison without parole.
There are a couple pieces in there. I'm going to try to address all of them. The first is talking about presumptions. I absolutely agree. What this court has said is there is a presumption against life without parole, and that must mean that the state bears the burden to show that this case is the uncommon juvenile offender. But it can't be that the state bears the burden on every single prong of that 5-factor Miller and Lyle test. We can't get inside the juvenile's head. The best evidence about his character is probably what's happening up here. We can only look at indirect evidence of that, and the best evidence for Isaiah Sweet's character, for his demeanor, for his prospects of rehabilitation.
Factors, and if you read Miller, the factors are used to assess whether or not he is irreparably corrupt beyond rehabilitation.
I agree.
Because the United States Supreme Court said you use those factors to determine if this person can or cannot be rehabilitated given his diminished capacity, diminished responsibility, he's still growing, the brain isn't fixed till they're 25, they had all those factors. So we could argue each factor, but what you have to tell me is how these factors point to that you've met that burden, that this kid, at least under this record, is in that 25% that is not rehabilitated, cannot be rehabilitated.
This isn't the kind of crime that we expect juvenile offenders to commit. All the general principles, all the most juvenile offenders behave this way, are for impulsive, impetuous juvenile acts. A juvenile that vandalizes a building, steals, maybe even commits a robbery falls within what the general statistics talk about. This is not one of those cases. This is not impulsive or impetuous. This is planned. This is an adult crime.
The expert, if I read the testimony correctly, said that this case, the 75% figure that he threw out included murder situations.
Your Honor, the district court correctly found this was not credible expert testimony. What this expert did was
Well,
walk
the district
into
court didn't quite do that. The district court said that his testimony was, do I have it right, overstated or over-optimistic, I think maybe, or I'm pretty
over-optimistic.
Pretty close. All right. And that could be 75-25. He's saying 3/4 of them age out, basically. And the district court's saying, well, that's over-optimistic. But still, the lodestone, as Justice Wiggins has rightly said, I think, is irreparable character.
Irreparably corrupt.
Irreparably corrupt. I was fumbling for it. And all these factors kind of lead to that road. Boy, isn't that hard to do in this record?
I don't think it is. And I didn't quite get a chance to explain why credibility is what we're talking about. One of the things the judge said was that this was an overly optimistic assessment, but that's not the only problem with this expert's testimony. The problem is that this expert walked in, spouted off some statistics, and did nothing to tie it to this offender. The district court judge rightly recognized that you can look at this general universe of statistics, but that's not helpful to anyone if it's not tied to this offender. And this offender does not fit the profile for an impetuous or impulsive act.
That's the whole point of having individualized sentencing, where a competent defense attorney would have this person evaluated to see if he's in the 25 or the 75, if those figures are right, and maybe a competent county attorney would do the same thing, and a judge could make the decision. I mean, the judge was just speculating he's not in the 25%. I mean, he's not in the 75%. And that's the purpose for an individual hearing. How do these factors play out with this kid? And I think we made that clear in Seats, that we send it back for somebody to do that. And I don't know if our lawyers will do that, but that's what they need to do.
Your Honor, I think the judge did do that here. Irreparably corrupt are not magic words. The judge said exactly that, just
I'm not
using
talking
different
about what the
language.
judge did. I'm talking about the lawyers representing these people should do. No one had this kid evaluated. No one had this kid looked at of what his possibilities for rehabilitation. Nobody did any of that. And if you're going to have an individualized hearing, I hope you focus on the individual, not bring in an expert that says 75-25, but I don't know where it is. I mean, that's my problem with the whole thing at this point, because nobody took the time to see where this kid fits applying these factors. No professional, no lawyer, and nothing. And that's what bothers me about this. Now, if he deserves life in prison without parole, so be it. I mean, if that's what the law requires, it does. but at least have a real hearing, not one of these 2-hour, 3-hour sentencing hearings that they have on these things, when you're going to decide whether someone's going to spend the rest of their life in jail.
Your Honor, I very strongly disagree with your assessment of what the lawyers and what the judge did here. I think the judge and the lawyers did make a good faith effort to comply with all of the case law. The best window into this offender's character is what he did when he murdered Janet and Richard Sweet. That tells us more about this offender than having him sit down with a psychologist.
But the Supreme Court has generally said, it is general and subject to jockeying around, but I mean, they've basically said in first-degree murder cases that it's a little bit Sphinx-like. That's why we're here. But that life without parole for juveniles who commit first-degree murder should be rare and uncommon, and reserves the categorical issue. So it seems to me most, as I read that case at least, most first-degree juvenile murders, at a minimum under the Supreme Court, will not be life without parole. They leave open the door, and it looks to me like there may have been some maneuvering among the Supreme, judges do that, of course, and I'm not being critical. They didn't quite know whether to go categorical or not. They left it open. But it's supposed to be rare and uncommon, and I think you understand that framework at least.
That's certainly what the court has said. I don't dispute that at all.
Yeah, okay, and that's what we're, in the confines of our case law, that's what we're working with some elaboration and seats and all and whatever.
Sure.
Well, and that's where I guess I want to make the comment that this is all part of the evolutionary process of developing this juvenile jurisprudence. So wouldn't you agree that with the benefit of seats, it may be more appropriate to have another hearing on this to develop the record as Justice Wiggins has suggested with guidance, now with seats, even with the comments from the court. I think your position, of course, is that we should just affirm whatever the district court did is not an abuse of discretion. But now with the benefit of having seats, having additional discussion about this, and setting forth some additional parameters, wouldn't you agree that the most appropriate thing at a minimum would be to send it down for a further development of the record as Justice Wiggins suggested?
I wouldn't, Your Honor, and there are a couple of reasons why. The first is, honestly, I've sat down, I've read seats a couple of dozen times. I am honestly at a loss for what it says that our case law did not already say. I've read it and read it and read it. We talk about irreparable corruption, but like I said before, that's not magic words. That's what the judge did here. This is a highly culpable offender. We can learn a lot about his character from how he thought to use earmuffs to protect his own hearing and then pick the bullets that would do the most damage. That tells us a lot. And we know that there's no real prospect for rehabilitation here. We don't use the word sociopath anymore because it's not in vogue with people at the APA, but that's what this offender is. If you listen to the tape, if you look at the transcript, he's callous, he's cold-hearted, and there is no reason whatsoever to think he will ever be anything else.
Mr. Buller, that really doesn't tell us much about what that person is going to be like once they have a fully developed brain. And would it be a better approach to simply adopt a categorical process and allow the parole board years later to make a determination based upon not the guesswork of the trial judge when the person is 17 or 18 years old, but when they're 30 or 35 or 40, and we can find out what they really turned out to be?
There are three reasons that counsel strongly against the categorical rule. I'm going to try and get through all of them. The first is that that's an important policy question. There are big policy decisions to be made there. And some of the questions we've heard today would be great campaign or floor speeches at the Iowa legislature, but of course that's not where we are. The court's role is interpreting a cruel and unusual punishment challenge.
Okay,
it's at the narrow margins at the outside.
But in Roper, the Supreme Court adopted a categorical rule, correct?
Yes, and I think death is different is something you see all over the jurisprudence.
Sorry?
And you see that death is different and that this higher level of penalty is different all over the jurisprudence. What you don't see, and this is my second reason, is other courts following this rule. One court anywhere in the country has adopted this categorical bar. That reflects Americans' values. That's why we shouldn't be looking at international law. Foreign law has no place in what we're talking about here. There's nothing in the text or history of the Iowa Constitution that suggests we care at all about what France or Australians are doing.
Oh, but even if we follow what the United States Supreme Court is going to do, there's a fair chance they're going categorical as I read the cases. One of the things they emphasize, and this is what the American Psychological Association has said, is that I'll paraphrase a little bit, that this predictive stuff with juveniles is extraordinarily difficult. And the American Psychological Association has basically taken the position is that even in these heinous crimes, and this is a heinous crime, the predictive tools are just not available for us, and therefore, it's kind of kick the can down the road, but let's wait and observe. And if they're really sociopaths, they'll be apparent at age 40 or whatever it is. So that's what the psychologist tells us, and why isn't that good counsel?
With the Chief's permission, I'll go ahead and answer the question. Your Honor, in order to adopt that full belief that basically the parole board is the one that should be making all these decisions, this court would have to walk back what it said as recently as in Lyle. This court has entrusted the district court with a lot of respect and with having the tools they need in order to make these sentencing decisions. That's been true for 150 years in Iowa. All we're asking district court judges to do is what they've always done, to make the punishment fit both the offense and the offender. This court has said, yes, you have discretion at the lower end. Less culpable juvenile offenders should get less time. All we're asking for is the same at the upper end, that greater culpability should result in a greater penalty.
I have one question, and I know we're over time, but just because we would, this gentleman, Mr. Sweet, would get life in prison with parole doesn't mean he's ever getting out. You'd agree with that, because then it's up to the parole board. And isn't it better, at least 20 years from now or 30 years or 40 years from now, whenever he's up for parole, and I don't know how that works, that the state could go in there and the victims go in there, can say, well, based on, because they'll do psychological testing before they'll release them on parole, because they do the stuff that we talked about that wasn't done here for sentencing. Isn't it better and more predictive, following up on Justice Appel's question, that they'll have current information at the time, and if he's not rehabilitated, he's going to sit in jail and he's going to die in jail. But for us to guess now as to what's going to happen on this record seems to me a little draconian. How would you answer that?
There are a lot of reasons, again, that counsel against that. First, it's not this court's role to make that kind of policy decision. That decision belongs to the Gold Dome. Second, we trust district court judges to make exactly this kind of assessment in every single case that comes before them. Is sentencing perfect? Of course not. No one's going to say it is. But like I said before, for 150 years, we've trusted the district court with these tools. I don't see any reason why this is so fundamentally different, because the converse of your point, that it's possible that Sweet won't get out if sentenced to life without parole, is that even if he does receive that sentence, he might get out someday. There are mechanisms put in place in the Iowa Constitution and in the Iowa Code by which he could receive a commutation.
And if he does get out, counsel, as you just posited, wouldn't that be as a consequence of the highest form of individualized sentencing, which took into account where this offender ended up and what his potential for rehabilitation really was?
Well, I think there are reasons both for and against that analysis. The parole board has different tools than a district court judge does. I'm not sure they are better tools to address your point. The district court judge here is in a particularly unique situation because he sat through a trial. So it's sort of an odd guilty plea that happened after the state put on all of its evidence.
Well, the parole board, on the other hand, is operating years down the road and doesn't have to engage in as much speculation and conjecture as the sentencing court does if there's not a categorical rule.
But
correct?
that's just on one piece of the reasons that we impose punishment. They might have more or even arguably better tools to assess rehabilitation, but that is not the only reason that we punish criminal offenders. We punish criminal offenders to express morality. That's the legislature's role. We also punish criminal offenders to protect the community. And there is no question that if Isaiah Sweet is released, he will kill again. I would ask this court to affirm the sentence imposed.
Thank you, Mr. Buller. Rebuttal argument?
We don't know everything about Isaiah Sweet. We don't know who Isaiah Sweet will be in 25 years, in 50 years. And that's why, as Justice Wiggins pointed out, we don't know if he gets given life with parole, whether he will ever be released. He would have to prove that he has matured and rehabilitated himself, and only then would the parole board, with a better view, would be able to determine whether he would be fit for release. It is a better idea than having a district court judge with only a limited view and only speculative or only able to speculate as to the future, determining this very drastic sentence, because life without parole is irrevocable. It is a death sentence that he will live and die within the prison system. Justice Kagan, in her opinion, in Miller, she assumed that life without parole she assumed that it would be rarely, if ever, imposed. I don't think that's happening here. As I said earlier, we have it imposed in Mr. Sweet's case. We had it imposed in Mr. Seat's case. In the other case that has been requested to be considered today, and there are other cases out there that are on the court's docket of life with parole, and Miller is only 3 years old. If this court was to impose or to hold there as a categorical bar, that's not overruling Lyle and the related cases, because this is different. We're not talking a mandatory minimum. We're talking life without parole. We're talking murder cases. It's just on a different level. As I said, it's irrevocable. It's just, you can't go back. You're saying that they're so corrupt that they can never re-enter society. But juveniles, as I said earlier, they're a work in progress. They're still developing, and we can't know who they're going to be. So for those reasons and the reasons stated in my brief, I respectfully request this court to reverse his sentence and find there's a categorical bar to life without parole for juveniles.
Thank you, Ms. Knipfer. Thank you as well, Mr. Buller. The case of State versus Sweet is now then submitted to the court, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.